All right, we're now on the record for Wednesday morning, November 10, 2021 civil docket. I'll start with quick announcements. Mr. Gomez?
Good morning, Judge Randall Gomez. I have number 7 and 8, both with Mr. Rodriguez.
Good morning, Judge. Here on behalf of plaintiff in both cases.
Good morning. Then let's start with CL 21-0274-I, Pedro Sanchez versus Allstate.
Your Honor, Victor Rodriguez here for the plaintiff. We're here in a status conference and we've settled the case, Judge. We just need a couple more weeks to finalize the settlement paperwork and should be off your docket pretty soon.
Okay.
Yeah.
How much time do you all think? Just so I'll set a tickler.
3 weeks should be sufficient. Or what do you think, Randy?
Yeah. I was going to tell you that the checks have actually come in. So
Great. So 2 weeks, Judge, should be sufficient.
All right, I'll just set a tickler for December the 3rd.
Perfect.
And then if I don't see anything come in by then we'll go ahead and set you up. All right, the next case, CL 21-0959-I, Maria Estela Salinas versus Allstate, and the announcement.
Victor Rodriguez here, Your Honor, for plaintiff, same announcement. Case is settled and just need a couple of weeks to get everything
Okay.
final.
Mr. Gomez, have those checks come in by chance?
that one, I know we requested them in actually last month. And so if they're not in, I'm about to message the adjuster and see if we can get them in as soon as possible.
Okay, I'll set a tickler for December the 17th. For that, I'll give you a little bit more time.
Thank
Okay.
you.
Thank you, Your Honor. That's all we have. Can I be excused?
Yes, you may
Thank
be.
you so much.
Thank you.
Have a great day.
Thank you. Okay, Mr. Gorena?
Good morning, Judge. David Guarena. Myself and Savannah Gonzalez have number 11 on the docket, Judge.
Good morning, Judge.
Okay, good morning. And that's F 1320-20-9 in the matter of the marriage of David Lopez and Stephanie Vallejo. Are we proving it up then?
Not yet, Judge. I apologize. We did settle it at the mediation. My mistake. Ms. Gonzalez did send me the decree. I thought my assistant had sent it to my client. She thought I did. We just sent it to him this morning. So we need about a week, I guess, so we can submit it to the court.
Okay.
Well, Judge, on that note, is it okay if we prove it up and then we just submit an agreed order signed by all?
That's fine.
Yes, that's fine if you have your clients on.
They're present.
All right, Mr. Lopez and Ms. Vallejo, do they both speak English?
Yes, ma'am.
Yes.
Okay, I see Ms. Vallejo. Where's Mr. Lopez?
Mr. Lopez is on there, Judge. He's on the screen. Well, I don't see him. He's not on. His name is on there, but he hasn't set up his
Camera. Mr. Ubalde, please take your cap off. Thank you. Okay, Mr. David Lopez, if you can hear me, please start your video, sir.
There he is.
Okay, thank you. All right, can you please both unmute yourselves?
Yes.
And let me have you both raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Vallejo
Yes.
and Mr. Lopez?
Yes.
All right, and who's gonna prove it up?
I can prove it up, Judge. I have the petition here in front of me.
Okay, go ahead, sir.
Mr. Lopez, would you state your full name, please?
David Lopez Jr.
And Mr. Lopez, you're married to Stephanie Azeneth Vallejo, is that correct?
Yes.
And prior to the filing,
I'm sorry, you can lower your hand, Mr. Lopez.
Oh.
Thank you. Go ahead, Mr. Guarena.
prior to filing this petition for divorce, have you been a resident of the state of Texas for 6 months and of Hidalgo County for 90 days?
Yes.
And you allege in your petition that your marriage has become insupportable because of discord or conflict between yourself and the respondent that destroys the legitimate ends of the marriage relationship. Is that true?
Yes.
And it also states that you were married on February 10th, 2017. You ceased to live together on or about November 10th of 2019. Is that correct?
Yes.
And as a result of the marriage, you have one son together. That's Devin Ian Lopez.
Yes.
And have you and Ms. Vallejo reached an agreement regarding conservatorship, visitation, child support, medical support, et cetera, as far as issues with the child?
Yes.
And is that agreement that you would both be appointed joint managing conservators? That you would be, that you would have the exclusive right to establish the primary residence of the child restricted to Hidalgo County? Also that Ms. Vallejo would have the exclusive right to enroll the child in the school of her choice. And the child is currently enrolled at Monte Alto Elementary, is that correct?
Yes.
And the agreement is that the child will finish this semester there at Monte Alto, and then in the spring semester, Ms. Vallejo will choose which school he will be attending, is that correct?
Yes.
And also the agreement is, as far as visitation, the child is basically going to be with each party for 50% of the time. And as set out in the mediated settlement agreements, each week will begin on Friday when school is released, and then the parties will be exchanging the child every Friday. Is that correct?
Yes.
And as far as holidays, those visitations for Thanksgiving and Christmas will be as per set out in the family code. Is that correct?
Yes.
Also, the pickup and delivery will be at the school that the child attends. If school is not in session, then the pickup and drop off will be at the Flying J truck stop in Edinburgh, Texas. Is that correct?
Yes.
And each party may designate a competent adult with a valid driver's license to pick up and drop off the child. Is that correct?
Yes.
Also, the party not in possession of the child shall have daily communication with the child between the hours of 6 p.m. and 8 p.m. Is that correct?
Yes.
Also, there's an agreement that neither party will pay child support and that the child will be, I believe he's qualified for Medicaid, so each party will be paying 50% of the reimbursement of $57 for the Medicaid. Is that correct?
Yes.
And that each of you will be responsible for any uncovered medical expenses, 50% each. Is that correct?
Yes.
The parties also agree that there's no arrears in child support as of October 31st of 2021. That Ms. Vallejo will claim the child as a tax exemption in the odd numbered years. You'll claim the child as a tax exemption in the even numbered years. Is that correct?
Yes.
Okay, also, as far as the property division, each party is to keep whatever personal belongings they have in their possession. Is that correct?
Yes.
There are some things that you have, or you may have, that belong to Ms. Vallejo, including a 40-inch TV, a full-size bed that the child would use, and an armoire. Is that correct? And you're agreeing to let her have those items.
Yes.
And as far as there is a vehicle that you have together, that's a 2014 Nissan Rogue. You're going to keep that vehicle, and you have tendered to Ms. Vallejo a check in the amount of $2,000 for her interest in that vehicle. Is that correct?
Yes.
And also, you are asking the court for a divorce.
Yes.
I'll pass the witness, Judge.
All right, Ms. Gonzalez?
I'm sorry, Judge. No questions of this witness. If I can just question mine.
Yes.
Ms. Vallejo, can you hear me?
Yes.
Okay, great. Did you hear all of the questions that were asked of David Lopez?
Yes, ma'am.
Okay, and are you in agreement with these responses?
Yes, ma'am.
Okay, I need to ask you, during the marriage, other than your son Devin, did you have any other children regardless of who the father may be?
No, ma'am.
Okay, and you're not currently pregnant or expecting a child, correct?
No.
And you did not adopt any other children, correct?
No.
Do you believe that the provisions regarding conservatorship and possession and access of Devin are in his best interest?
Yes, ma'am.
Okay, did you receive the $2,000 for your interest in the vehicle already?
Yes.
And have you been able to collect your other belongings pursuant to the mediated settlement agreement?
Yes.
Do you believe that that division is fair and equitable? In other words, it's a good separation of all of the assets in the marriage.
Yes.
Okay. Are you asking this court to grant you a divorce?
Yes, ma'am.
Pass the witness, Judge.
Okay,
Questions,
Mr.
Your Honor?
Moreno?
No questions, Judge.
All right. Then the court is taking judicial notice of all the documents in the court's file. And specifically that it's all been on file within the required amount of time. Also, the court is granting the relief as requested and testified to on the record and does pronounce the parties divorced. And that'll be set forth in a final decree of divorce to be signed off by the parties and the attorneys. And how much time do you need to submit that?
I don't think we need more than a week, Judge.
All right. I'll just go ahead and put a tickler for the 19th.
Yes, ma'am.
And Your Honor, if I can just confirm the mediated settlement agreement was filed, is that correct? I believe we filed it the day after the mediation.
If somebody on my staff can check to see that it's on
Your Honor,
file.
I do see that it was filed on the 29th of October.
Okay. All right, it's been filed.
Thank you, Judge.
Okay. Anything else?
That's all we have, Your Honor. May we be excused?
Yes, and I wish you the best of luck and commend you for putting your child first. All right,
Thank you,
Thank you,
Judge.
Judge.
you're excused.
Judge, I do have a quick question on number 10 on your docket, in matter of the marriage of Daisy Trevino. I'm the ad litem on that, but I couldn't get a hold of either party. Is that still on your docket?
Yes, Ms. Trevino is on and Mr. Cejas is here. And we're just waiting on Ms. Del Bosque, if you want
I'll
to
be
be
on
on standby.
And Your Honor,
Yes,
my
ma'am.
understanding is Ms. Del Bosque is in another hearing, but she'll be joining us shortly.
Okay,
Thank
all
you.
right, I'll take you up momentarily. Okay, Ms. Ramirez, Tony Ramirez? All right, Mr. Martinez, Jose Martinez.
Good morning, Judge. I have F 1843-21-9, Benito Ubalde and Karen Ubalde agreed divorce.
Okay, that's number 3 on the court's docket. And is there already a divorce decree on file or are you proving it up first?
We're proving it up first, Judge.
Okay. And I do see Mr. Ubalde, and is Ms. Ubalde here?
No, she's not. She's working and not able to appear. She signed a waiver, Judge.
All right, Mr. Ubalde, please please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please unmute yourselves.
Yes.
Okay, go ahead, Mr. Martinez.
Is your name Benito Ubalde Jr.,
Yes.
married to Karen Ubalde?
Yes.
At the time of this filing, had you been living in Texas for 6 months and Hidalgo County for 90 days?
Yes.
Has your wife signed and filed a waiver of citation?
Yes.
Were you married on or about 2008 and ceased to live together on or about November 1st, 2020?
Yes.
Has the marriage become insupportable because of discord or conflict of personalities that destroys the marriage?
Yes.
Is there any hope of reconciliation?
No.
And you have 2 children, Gael, Gael,
Yes.
and Diego, is that correct?
Yes.
And you're going to be joint managing conservators with your wife as a primary, is that correct?
Yes.
And you've agreed to standard visitation rights
Yes.
and child support is going to be in the amount of about $2,000 per month, but you're going to be paying for the home, which you're giving to your wife, and for 3 vehicles, a Jeep, a GMC, and a Dodge. Is that correct?
Correct.
And your wife is in agreement with this, is that correct?
Yes. Correct.
And you're asking for the court to award her her personal property and to award you your personal property that you have in your possession. Yes? Benito?
Looks like he froze.
Yeah. Benito, are you there? Judge, I'd ask that the court order that personal property be placed in the party in possession. That was going to be my last question.
Okay, and then we lost him completely.
I'll submit a decree with both parties' signature, Judge.
Okay, then I'll accept the testimony that has been put on thus far. And I'll pronounce them divorce and go ahead and submit a decree that has their signatures on it and your signature. That should be fine.
Thank you, Judge. That's all I have, man. Oh, no, I have one other case. Thank you, Judge.
Okay, what's your next case?
It's with Felipe Garcia and I think Aaron Vela.
Okay, that's CL 164509-I, Humberto Flores versus A. Garcia Produce.
That's it, Your Honor. Felipe Garcia here for Humberto Flores.
Yes, Your Honor. Aaron Vela here for A. Garcia Produce and for Mr. Garcia individually.
All right, and what is the announcement, gentlemen?
Well, Your Honor, we were set for status this morning. We had a status back in August and then the court reset us for today.
Okay, and have y'all made any progress on the case?
The deposition of my client was taken. We've exchanged discovery. I got an email from Mr. Garcia earlier this week or late last week regarding some documents I'd requested. There's going to be a delay in that because we're going to have to request them from the IRS. But we are moving forward on discovery, Your Honor. Still need to take some depositions, but just advising the court as to what's happening.
Okay, and so when do you think that you all are looking at concluding the discovery period so that you can go to mediation?
Your Honor, I need maybe 45 days to get these records, maybe 2 months. My client, besides getting the documents from IRS, is a over the cross-country type of truck driver. Last week I talked to him, and on Friday said he had just gotten to Chicago with a load of produce from the valley. And from there, he was going on to Dallas to take chicken. And then he was coming down back here to pick up another load. And so that's the man's work schedule. I'm not trying to belabor this. I know this is a 2016 case, but we were at least a little over 2 years, maybe on appeal on the jurisdictional issue. But we are going forward.
Okay, so then would you all say that within the next 90 days, you'd be ready to mediate?
I would hope so, Your Honor. I would think so.
Mr. Vela?
Likely, Your Honor. Depends on what I've asked for a bunch of tax return information. And if the plaintiff doesn't have it, we'd have to request it from the IRS. That might take a while, but we are moving forward, Your Honor. And there's no purposeful delays or anything on our end. We're just trying to get through it. And then I'd like to take the deposition of the plaintiff as well. And that's going to kind of depend on the schedule. But we're moving forward. And hopefully once we get that done, Your Honor, I don't think anybody here has any objection to mediating the case. We just need to get enough information to make it meaningful.
Okay, let's go ahead and have y'all come back on March the 7th at 9:30. And that should give you enough time to see how far you can progress between now and then.
March 7, Your Honor?
Yes.
Okay, thank you.
Okay, anything else on that?
Nothing, Your Honor. May I be excused?
Yes, sir.
No, Your Honor,
Okay.
thank you. Have a great day.
No, Your Honor, thank you.
Thank you. Okay, Ms. Ramirez?
Yes, Your Honor, can you hear me?
Yes, I can now.
We have a case with the Attorney General, Ms. Romero, and Ms. Dulce Hernandez.
Okay.
It's number 1 on your list.
F 2539-09-9, and I do see Ms. Hernandez on, and I do see the Office of the Attorney General also is on.
Your Honor, since we had not spoken to Ms. Romero, we had another Assistant Attorney General handling this case. And we haven't had a chance to talk to the new Assistant Attorney General. I believe Ms. Romero had wanted to see if we could go into the break room for just a few minutes.
Okay, that's fine with me. Are you all still wanting to go into a break room?
Yes, Your Honor, just to confer with about the numbers really quickly.
Okay, and that's all three of you, correct?
Yes.
Yes, Your Honor.
Okay, let me go ahead and set that up for you.
Thank you.
You should see the invitation. Okay, Mr. Cejas, I did see that Ms. Cantu del Bosque is on. You want to do your announcement?
Yes, good morning, Your Honor. Yuri Sejas here on behalf of Daisy Trevino. It's number 10 on the court's docket.
F 4752-19-9. Go ahead, Ms. Cantu del Bosque.
I'm sorry. Good morning, Your Honor. Cynthia Cantu del Bosque on behalf of the respondent Carlos Trevino.
And we also have Ms. Gonzalez.
Yes, ma'am. Savannah Gonzalez as the ad litem for the minor child judge.
All right, and what is the announcement?
Yuri, you called us in here for a status. We had, it's a continuation from an October 6th hearing. We had submitted and agreed temporary orders. The parties are operating under those those amended temporary orders. Ms. Del Bosque has sent us some discovery, which we hope to answer and get this thing resolved hopefully before the end of the year.
Okay.
Judge, yes, just for the court's information, we are supposed to mediate, or we had scheduled or tried scheduling a mediation for the week of the 15th, which is next week. However, I did send correspondence to Ms. Klein indicating that that probably wouldn't be feasible since we still have some discovery pending. I'm also pending petitioner supplemental responses from the first set of discovery, Judge.
Okay, and who have you all agreed to mediate with?
I believe it's Miss oh my goodness, I'm forgetting her name.
Signs.
Yes, they
I'm sorry, who?
Evelia Signs.
Okay.
Yes.
All right. Okay, well then I'll give you some time. I just didn't, because of the sensitivity of the case, I didn't want to lose track of it. And just to make sure that it's progressing, I was very pleased to see that you all had submitted those temporary orders and that something's in place right now. And so it tells me you all are working together to try to get some kind of resolution. That's, I mean, unfortunately, this is a very unique case. And I know it's requiring all of you all to think outside the box and to try to come up with something that is tailored to this situation. So for right now, I mean, I'm assuming you're going to be continuing to work up your discovery and then you'll go ahead and reschedule your mediation. But if we can see where you all are at by January the 31st.
At 9:30, Your Honor?
At 9:30, and that'll be a status unless you're ready for a final prove up, we can change it to that.
Thank you, Judge.
That's all the business we have before this honorable court may be excused, Judge.
You certainly may. Thank you very
Thank
much.
you, Your Honor. Have a great day.
Thank you, Ms. Cantu del Bosque. Thank you, Ms. Gonzalez. Thank you, Ms. Trevino.
Thank you.
Thank you, Judge.
Okay. Mr. Ramos, what do you have today?
Good morning, Your Honor. I have had your docket right here. Give me 1 second. It always sneaks away right when I need it. I'm here with Mr. Ismael Hinojosa on the other side on number 5 on your docket.
Oh, okay. F 2938-13-9 in the interest of a minor child.
Good morning, Your Honor. Ismael Hinojosa for Miss Jasmine Rodriguez.
Good morning.
And Your Honor, Juan Ramos here on behalf of Mr. Joshua Mancha, the father.
Okay. So let me see. Let me just write their names down. Juan Mancha. Okay. So we're here on a motion for child custody evaluation and an appointment of an ad litem.
Correct, Your Honor.
Okay, is that you all are not in agreement in doing those two things?
I spoke to Mr. Ramos yesterday, Your Honor. I think we're in agreement to doing them.
Yes, Your Honor.
Okay, then is the order on file?
I think I submitted a proposed order, Your Honor, but I'll double check. If it's not there, I'll submit another one.
Okay, so let me ask you, so custody is at issue?
Right now they have split custody, Your Honor. The biggest issue that my client has with it, one is now she is working from home, so she would be able to pick up the child, take the child to school, spend time with the child. I think, I'm sorry, is somebody want to say something?
No, I think somebody may be unmuted somewhere.
Oh, okay.
No, it wasn't your client.
She can pick up the child, stay with the child the whole day. She would like to have primary, and the other issue is communication among them is not good, Judge. My client has issues getting a hold of Mr. Mancha, some verbal abuse. And I think the one last issue we had is Mr. Mancha either directly or indirectly talking about the case, either to the child or where the child could hear.
Okay, let me ask you, so how many children are involved?
One, Your Honor.
One child.
And how old is that child?
I believe he's about to turn 10.
Oh, okay, all right, look, guys. Your attorneys know me very well. I'm going to speak to Mr. Mancha and Mr. Elias. So before I came on the bench, just so that you know, I practiced law for over 18 years. And the area that I practiced law in predominantly was family law. So lucky for you, you actually have an attorney that likes to hear family law cases and is very vested in family law cases. I'm going to tell you, the decisions that I make off the bench will always put the child first, always. And I believe that all of us have common sense. And so if you have a 10-year-old child, that 10-year-old child is very impressionable. And that also tells me that child is probably what, in 5th grade? Yes, okay. So the child is in 5th grade. Your child is about to, and it's a boy? Okay. So this child is halfway through 5th grade year, about to go into middle school, going to go through a lot of changes in personality, about to change schools and things of that nature. So I need for you all to really take a step back and look at the entire situation and really decide whether or not you want to bring these things forward, because I'm going to hear them. Some courts may not want to hear these cases, but I do hear these cases, and your attorneys can tell you that. So I'm going to, if you want to move forward with a child custody and with an ad litem, that's fine with me. I'll go ahead and now that they've agreed to, I'm going to order that to be done. And then those orders are already on file. My court coordinator let me know. So I'm going to have those forwarded to my queue, and that will get done. All right. But just remember that the more you go into this case, and I'm sure your attorneys are going to tell you that the more you go into this case, the deeper you go, the more you're opening yourselves up to exposure, both of you. All right. And so think about that. And the other thing that you also need to think about is how much of this is really from the standpoint of the best interest of the child, and how much of this is what I want. Those are all things that you need to discuss with your attorney. And if these things don't always work, so don't get me wrong, 50-50 doesn't always work, and AB plans don't always work, customized possession orders don't always work, and standard doesn't always work, and sometimes you do have to think outside of the box. So I get it, and orders do become unworkable. But I do believe in putting the majority of the control of the case in your hands. I really do, because I don't live your life. I don't know what it's like to be Mr. Mancha. I don't know what it's like to be Ms. Rodriguez. And like I used to tell my former clients, I have enough drama in my own life. I definitely don't want to know what anybody else's drama is like, right? So right now you have a lot of control. So you have to decide how much of that control you're going to relinquish, okay? Now just remember, what I'm telling you is that if you're wanting to relinquish it, I'm willing to take it with open arms, okay? So listen to your attorneys, listen to what your next steps are going to be. I'm not saying that the things that you are claiming are not happening, absolutely not. Absolutely not. And I'm not saying that they are happening. Absolutely not. Everyone has a perspective to their situation, and I'm very aware of that. That's why we have this forum. That's why you have an advocate of your attorney, because if each of you thought the same, you wouldn't be here, right? You wouldn't be here. So both of you obviously don't agree, and that's okay. All I'm going to tell you is please keep your son first in your thoughts, because that's who I'm going to be keeping first. Because this can't be easy on you all. This really can't. No, anytime you come before the court, the uncertainty, the not knowing what is the judge going to do, what's going to happen, that can't be easy. And you're asking, and you're putting it in the hands of a complete stranger. But just know that right now you have a lot of control. So decide how much of that control you want to keep and how much you want to relinquish. And, but I'm here to hear you all right? So I'm going to go ahead and get those forwarded to my queue. I'm going to sign off on them. The ad litem should be making contact with you all as soon as they receive the order. And then they will get started on the case. So do you all have any other pending motions, Mr. Hinojosa or Mr. Ramos?
No,
Not currently, Your Honor, I don't believe so.
Okay, so is this, are we in a SAPSR? Is this a modification? Is there already a previous order? What's that status?
There's previous temporary orders, Your Honor.
Okay.
Yes, I believe this is a SAPSR.
Correct.
All right.
On temporary orders.
Okay, so the temporary orders that right now those have already been filed and signed.
Correct.
Okay.
Yes, Your Honor.
And when
And
was
I
that?
believe they've been in place, I believe, Your Honor, for about 2 years now.
Oh, no.
That's correct, Your
Honor. Okay. Yeah. So, well, I mean, things happen, life happens. All right. So now we're going to get moving with it then, right? Okay. Yeah,
Yes,
I can see. So temporary orders are meant to be temporary, right? But sometimes you do end up, things happen and of that nature. So, all right. So I'll go ahead and get those out to you. And then what are you going to be doing? Are you filing a motion to, is there a modification? Or are you wanting to do all this for temp orders, or what are we doing?
Our position, Your Honor, we're trying to finalize the case.
Okay.
Mm-hmm.
All right. So you're trying to finalize the case. So your next step is going to be just to work it up and then go to mediation and then see what needs to be done, correct?
Correct.
Yes, Your Honor.
Okay. What about discovery? Are you all going to go through the discovery process? Has there been an informal exchange of discovery or formal exchange of discovery?
So Judge, I came on this case late September, early October. As far as discovery, I'm still evaluating that. I believe, though, from our position, Judge, that this ad litem should assist with most of the issues that we have to address.
Okay.
I agree with that, Your Honor.
I'm assuming that since it's really just that one issue, you probably will have an exchange of possibly some text messages that you may need to look at. And, you're not going to be looking at anything else. We're not modifying anything else, right, at this point. Now, you're going to have to exchange some financial information between the parties, because
correct.
If you do change the visitation, then obviously that's going to be something you guys are going to be looking at, right? So
yes.
Okay. All right. So let's go ahead and I'm gonna allow you some time to work up the case. Now, in your temporary orders, do you all address holidays?
I believe
it does, Your Honor.
Yeah, it does, Your Honor.
All right. So we don't have any issues with the upcoming holiday season then?
No, there are already orders in place.
Perfect. All right. So what we're going to do is I'm going to allow you to go ahead and continue to work it up, and we're going to come back for a status on January the 31st at 9:30.
Will do, Your Honor.
Yes, Your Honor.
Okay. All right, anything
I have no
else?
questions of this witness, Your Honor.
Okay.
That wasn't the question. There was an exhibit.
Okay.
No, nothing further, Your Honor.
Juan, are you in another court or what?
No, it's Mr. Hinojosa. Usually it's me though.
Oh, okay. All right. Okay, well then I'll let you all go. Mr. Ramos, on an unrelated case, I believe my court coordinator was needing to contact you with respect to one of your contested hearings. If you can please contact our office.
I'll talk with Bianca as soon as I get off.
Okay, thank you. All right,
Thank
then
you,
if
Anna.
nothing further, we'll see you on January the 31st. And I hope that you all have a great holiday season, Mr. Mancha and Ms. Rodriguez.
Thank you. Me too.
Okay,
thank
you all are excused.
Thank
Yeah,
you, Judge.
Okay, give me 1 minute.
I think she took a break. No.
Okay. We're on the record. Sorry, I had to get my coffee. All right, Ms. Ramirez and Ms. Hernandez, are we ready?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay, so what are we doing? Are we just gonna submit the order or,
We're gonna put it in the record.
oh, so we haven't proved it up yet?
No, we haven't.
Okay, so give me the names of the parties.
Maria Antonia Ramirez for movement, Juan Miguel Cortez.
Okay,
Dulce Hernandez, Your Honor, on behalf of Crystal Eileen Garcia. She's a respondent and she's on the screen, Your Honor.
okay. So, Ms. Garcia, raise your hand. All right, and who is that next to you, ma'am? Unmute yourself.
I'm sorry, that's my daughter.
And is she a party to this case?
Yes, she is.
Okay, then I need her to step out of the room
Okay.
to a location where she cannot hear what is being said.
Okay.
Thank you. All right, and do both parties speak English?
Yes, Your Honor.
Yes, Your Honor.
Okay, now put Mr. Cortez on the screen, please.
Right.
All right, both of you raise your right hand. Both of you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Garcia?
Yes, Your Honor.
Okay, leave yourself unmuted. And Mr. Cortez?
Yes, Your Honor.
All right, okay, Ms. Ramirez, you said you represented the movement?
Yes, Your Honor, the movement on the modification.
All right, go ahead. You can prove it up with him. Ask him the questions.
Yes, Your Honor, thank you. Your name is Juan Miguel Cortez,
Yes.
and the respondent is your ex-spouse, Crystal Eileen Garcia.
Yes.
And you are the parents of 2 children, Isaac Cortez. He was 17 on June the 24th,
Yes.
and Yaiza was 16 on October 21st.
Yes.
In the prior order of June 29th of 2017, Ms. Garcia was joint managing conservator who determined the residence of the children. Is that correct? Now, on February 24th.
I didn't hear his response.
Okay, Ms. Ramirez,
Yes.
he needs to be on camera and he needs to be the one, like, you can be off camera, Ms. Ramirez, and asking the questions, but I need him to be
Yes.
right in front of the camera so that my court reporter can hear what he has to say. So what is the last question that you were able to hear, Ms. Flores?
The last one she said, I just didn't hear his response at all.
Okay, so what was his response to your last question, Ms. Ramirez?
He said yes.
Okay, continue.
Oh, the last question? The last question was that On February 24th, 2019, the older child, Isaac, moved into his home.
Yes. Yes, Your Honor. Can you hear me?
Okay,
I can hear.
all right, go on.
All right, and Isaac has been living in your home up until now. Is that true?
Yes, Your Honor.
And you and Ms. Garcia have entered an agreement to modify the right for Isaac Cortez to live in your home, for you to determine the residence of the child. And the agreement is that you will be the parent to determine Isaac Cortez's residence. Is that true?
Yes.
And during this time, neither party will pay any child support since that day to the other party until the date that Isaac graduates from high school.
Yes.
Yes?
Yes.
Now you have 4 other children that you are supporting. Is that correct?
Yes.
I mean, 3 others and then 4 with Isaac.
Yes.
All right. And you will support Isaac and your 3 other children directly without paying any child support payments until Isaac graduates from high school.
Yes.
After the date that Isaac is no longer a child to be supported by you, you will begin on the following month to pay to Ms. Garcia child support of $160 per month and medical support of $57 per month. Is that correct?
Yes.
And there are also some provisions that you will that you've entered into because you do have a balance of arrears, and that will be asked through, I guess, through the Attorney General.
Yes.
So I will pass the witness to the Attorney General for her to go into those figures for the arrears prior to the date that Isaac moved into your home.
Yes.
Your Honor, what's pending before the court on our behalf is a motion for enforcement of child and medical support. At this time, we would move to non-suit our request for contempt findings in this matter and proceed on just the judgments.
Okay, the court will grant that. Go ahead.
Thank you, Your Honor. At this time, the state offers into evidence State's Exhibit A, the financial activity report, which is on file with the court.
Okay, any objections, counselors?
No objection, Your Honor.
Ms. Armidas, any objection?
No, Your Honor.
Okay, being no objection, those are admitted.
Thank you, Your Honor. Mr. Cortez, you had an opportunity to discuss the arrears that you owe from before the time that Isaac moved into your residence. Is that correct?
That's correct.
And it was explained to you that as of the 31st day of January 2019, you owed $7,260 with 3 cents for child support arrears?
Yes.
And you're agreeing to pay this back at $250 a month beginning December 1st of 2021?
Yes.
And when both of the children emancipate, if the arrears have still not been paid off, you will begin paying $410 a month towards that arrears balance.
Yes.
And it was explained to you that for medical support, you're in arrears as of the 31st day of January of 2019 in the amount of $1,062.75.
Yes.
And you have agreed to pay this back at $50 a month beginning December the 1st of 2021.
Yes.
I have no further questions for this witness, Your Honor. I would ask the witness and in addition ask that those judgments and payment plans be granted as requested.
Okay, Ms. Hernandez, did you want to cross-examine him?
No, Your Honor, but I do want to ask a couple of questions of my client, Your Honor.
Okay, go ahead.
Ms. Garcia, we've in English because the court reporter has to take it. We've had an opportunity to discuss what the agreement was. I know that this morning there's a new attorney general. You understand that, right? And so there were some changes on the numbers, but basically the amounts stay the same. Do you understand that?
Yes.
Okay, and you heard the questions and the answers from Mr. Isaac, and you're in agreement with those answers. Is that correct?
Yes, of Mr. Juan Cortez.
Yes, and you understand that the child support that he will be paying to you is $250 a month. Do you understand that?
Yes.
And it's going to start December 1st of this year.
Yes.
And he will be reimbursing Attorney General the amount of $50. Do you understand that?
Yes.
And as we discussed before, no child support is going to be owed to you or to him. You understand that, right?
Yes.
Because you have possession of your daughter and he has possession of your son. You understand that?
Yes.
And once your son graduates from high school, then that's when child support will start for your daughter. You understand that?
Yes.
And you're in agreement to the terms of this modification and enforcement. Is that correct?
Yes.
And once we get the orders, you will be signing those orders and we will submit those to the court. You understand that?
Yes, ma'am.
Okay. I have no further questions, Your Honor.
Thank you.
Okay. All right, anything else from the attorneys?
No, Your Honor, just that we ask for approval of the agreement.
Okay, then the court will approve the agreement as testified to on the record and will also order that that be set forth in further detail in an order to be signed off by all the attorneys and the parties. And how much time are you needing in order to get that done?
I think about 3 weeks because it's 3 attorneys.
Okay. Let's see. All right, then I'm going to go ahead and put a tickler for December the 10th.
Yes.
And that should give you plenty of time to get that in.
Yes, Your Honor.
Okay.
Okay. Thank
All
you.
right, well, good luck to you all.
Thank you.
Thank you.
All right, take care. Thank
Bye.
you. Okay, Mr. Guerrero, you ready?
Yes, Your Honor, we're ready. This is on F01082119, and I believe Silvano Molina, the respondent party to our motion to modify, is online right now.
Okay, and are both parties English speaking or Spanish speaking?
As far as I can tell, both of my client speaks English. I think Silvano, I've spoken to him in English.
Mr. Molina, are you English speaking or Spanish speaking?
Both, Your Honor.
Okay, well then we'll go with English if you understand English. Okay. And so do you have agreed temporary orders that you're putting onto the record, or what are we doing today?
Let me tell the court my request, and I'm not too sure whether Mr. Molina would agree to these things, but both children are now going to be living with Victoria Molina, his ex-wife, because Mr. Molina is agreeing to that, and he can tell the court if he's agreeing to that change in possession and custody.
Okay, so is this a what do we do? It's because it's styled as a divorce. So they're already divorced. It's not a
They're
divorce.
divorced, Your Honor. This is a modification of an existing decree of divorce. And there's been a change of custody and possession after entry. And we filed our motion to modify based on substantially changed circumstances.
How old are the children?
Now that's 16 and 13, Judge.
Oh, okay. All right, so both children are gonna go live with mom now.
Yes.
And Mr. Molina, is that your understanding?
No, Judge. One of the kids is currently living with his grandma. And I do not want to give up possession of my 16-year-old son. I believe that he is kind of, he's 16 years old. He's living with his grandma right now, not living with his mom. She does take care of him most of the time because, of course, I live in a different area. But that's my standing.
Well, Judge, so I respond briefly. Mr. Silvano Molina has married again. He's married to a Mexican national, lives in Reynosa. That prompted the filing of our motion. And he has every right to continue with his life. But the best place to place a young man is with the parent. I know he's 16 years old, and I know young men and young ladies have, opinions, but they're still minors, right? So we're asking for custody and possession to be temporarily granted to Miss Victoria Molina. And if we need to contest a permanent placement by a permanent modification, we can do it at a later date.
Okay, but he brought up an issue. Are these children with mom or are they with grandma?
The daughter is with mom and your son is with?
He lives Monday through Friday with my mother, his grandmother, because he wants to stay in that school district. The plan was for him to live with his father in Donna, but has since remarried and relocated to Reynosa. And it's just really unfair to pull my 16-year-old son from his friends and his school and his life. He already is not living with his father. He's not living in his home. And it's just unfair for us to pull him from his friends that he has known, this whole time. So
okay, so let's start with this. Now you open the door to this. Okay. So your children are 16 and 13.
Yes.
Have they been in the Donna Independent School District the entire time that they've been in school?
With the exception of my daughter, who has recently started with McAllen ISD as of this year.
Okay, so prior to starting with McAllen ISD, because I'm assuming it's that she's living with you, correct?
That's correct.
Okay, so before that, she was at Donna ISD.
Correct.
And so both your children were in Donna ISD up until this point?
Yes.
Okay, and your son is what, a sophomore or a junior?
He's a junior.
All right, and how are his grades?
Good. He's passing. He's a good kid. He's a good student.
Okay, so he's staying with grandma so that he can continue to go to that school district?
That's correct.
And what, do you pick him up on the weekends?
Friday evening.
Okay, and so Mr. Molina, are your plans to continue to live in Reynosa?
Yes, here is temporarily, Judge. I do plan to move back, hopefully very soon, but it is for now.
Okay, so this is, there's a misconception that when a party is given the right to decide the exclusive right to decide the primary residence of the children, there's a misconception that means that the child has to reside with them. And I know it sounds off the wall, but when a person is given that right to determine the exclusive right, when the person is given the exclusive right to determine the primary residency of the child, believe it or not, that means that it's okay for that parent to decide that the child is going to be with grandma for certain days or with an aunt or an uncle for certain days and come back. I know that people don't really understand that or realize that, but it's true. They can determine that the child will be with grandma, in this case, Monday through Friday, so that they can attend school, and then they get them on the weekend. Now, yes, you're right. You can also bring that up if it continues over a long period of time and you see that she is not having any kind of involvement in your son's life, well, then that's a different story. Now, of course, if what she's saying is true, she's allowed to do that under the code. If that's what is going to be happening, or that that's really what's happening right now. Now, while you're living in Reynosa, sir, I cannot allow for those children to live with you over there. They're going to be living here, and they're going to be educated where they're at right now. Now, if you move back and you move back permanently, then we can always revisit that issue. That's why it's temporary orders. We're not finalizing anything today. So if that's going to be the only issue for today, then, Ms. Molina will be the primary managing conservator with the person with the right to determine the exclusive residency of the children. And if that means that your son will be living with grandma during the week to attend school, that's actually allowed under the code. And then if you move back, you need to file your proper paperwork in order to do a modification. However, I don't know what are you all going to be doing as far as child support is concerned.
I've already filed a claim.
There's an order of child support of $300 a month under the decree. We'd like an order suspending any payment of child support going both ways until we get it resolved.
And who was the one ordered to pay the child support?
My client was Victoria Molina, was ordered to pay Silvano Molina $300 a month child support under the signed final decree of divorce in this case.
Okay. Well, since conservatorship will be changing, then we will be suspending child support at this time until we get that issue resolved as to who will permanently be the primary managing conservator. Okay.
And we'd like referral to mediation, Judge. There's other things that the decree would need to be sorted out between the parties, and Mr. Molina and Ms. Victoria Molina should be given an opportunity to try to work out the details. Maybe we can get an agreed to modification of the decree or modification of the SAPSR.
Okay, we'll submit an order of referral to you by the end of the day. Mr. Molina, can I get an email for you, sir?
Yes, I guess you can, Judge. It's Silver M, I like the color, then M as in Mary, 999949s@gmail.com.
Okay. Okay, thank you.
You're welcome.
Okay, anything else, Mr. Guerrero?
Nothing else, Judge. I will prepare the order. Does the court require Mr. Molina to sign off on it?
Not in this instance. You can just submit it with your signature, and then I'll sign off on it.
Okay, thank you, Your Honor. Well, may we be excused then, Judge?
Yes, you may be excused. Okay, best of luck to both of you.
Thank you, Judge.
Thank you, Judge.
Okay, Ms. Navarro, Perla Navarro.
Yes, Judge.
Okay, what do you have, ma'am?
We're docket number 2, and we're asking for a little more time. We're just ironing up the last with the mediator.
All right, you got it. Okay, how much time are you requesting?
We should be ready by the beginning of next month.
Okay, so then, let me see if I've got some room for you on the 15th. Do we still have a little bit of room on the 15th of December? All right, come back on December the 15th at
Yes, ma'am.
9:30.
Yes, ma'am. Thank you. May I
Okay,
be-
thank you, Ms. Navarro. Have a good day.
You too. Bye-bye.
Okay, so we're just waiting on the ones that were set for 11.
Yes, Judge.
I don't think number 14 is gonna, did they work it out?
I did speak to their office. She should be logging on soon, as well as I'm sorry, 14, I called both their offices, Judge. They'll be logging on, and as well as 13.
Okay, then we'll be off the record until I hear them chime in, okay?
Okay.
Thank you. Okay. All right, we're back on the record. I'm calling CL 174388-I. Anthony, Antoni, Jacobsi, Jakobsee et al. Versus Pulua, Pulloa, LCC et al. And what are the announcements?
Joe Scoello for the defendants, Your Honor.
You're on mute, Mr. Gibson.
Sorry, Stephen Gibson for the plaintiffs, and good job on pronouncing the plaintiffs' names. Nobody ever gets that right.
Go ahead. And what are we proceeding on a hearing on the third amended motion for sanctions?
Your Honor, yes, it's our motion for sanctions. And first of all, and I start this, I've been practicing for 33 years. I've never asked for sanctions before. I don't want sanctions against Mr. Gibson. I know Mr. Gibson. I just want him to comply with the court's orders. This is a case where his clients has sued my clients. We're ServPro, Your Honor. We do remediation. There was a big storm. Actually, it may have been a hurricane, if my recollection is correct. Their houses were damaged. One of the issues in the case is one of the plaintiffs, George Vela and Nancy Vela, received FEMA payments. We know this because I deposed Mr. Vela, and he confirmed that they received FEMA payments. Well, we're entitled to that information because it could come into play as far as any kind of credit that we might be able to get for it. That's a decision that the court will have to make at the trial court level, but it's certainly in the discovery point, we are entitled to that information. I don't think Mr. Gibson is disputing that. It's just that he hasn't provided me any documentation. If his clients don't have it, completely understand that, but I've provided authorizations for his clients to sign, and that will allow me to go get the documents myself. So that I can have them once the case goes to trial, and that's really the only issue that's involved here for this particular motion, Your Honor.
No, Joe, Mr. Escobedo is correct on what he said. My clients are not in possession of those things. They are documents that would be received from FEMA. I never knew FEMA was so difficult to deal with. They sent, upon the initial request, they sent us back a letter, or send the individual client a letter, because the client actually had to request the records, not the law office. And they give a link to go to and type it passcode in to download, like for for example, for the Jacobsees, I think it was some 300 pages that were found that were responsive to our request that Mr. Escobedo wants. And I certainly will give those to him. It's just that every time we call the line or whatever, they tend to not give us any solution to the problem. I guess getting a passcode and everything like that. Now we're having the same issue with the Velas. I can show you the letter I have from them. Let's see if I can find it here. That we have actually requested the records. So that's not anything, a failure on our part. Requesting the records, it's just obtaining them through FEMA. And I know this is Joe, it's like 5 years now? 4 years?
Something like that.
And the FEMA issue didn't become, I think that was like last year that became a topic in our case. But I wanted to show the court the documents, but I'm not finding it here on my case management system. But in any event, we have I'm going to try something else to get those documents, but they have identified that there are responsive documents. I think I produced a letter to Mr. Escobedo. If not, I will right now. And maybe just, Joel, I can get together. I come to your office. I can show you what I have, and maybe you can come up with some ideas, or I don't know if.
I don't mind trying that, Your Honor. I'm not saying Mr. Gibson hasn't been trying. It's just that I have a client that's on my back to try to get these documents so that we can then depose Mr. Vela. I would ask. I have no problem getting Mr. Gibson, and I will do that. But I would ask that the court, order him to have his clients sign the authorizations we provided him, so that we can also try to get those documents. And then if he could provide this to us in the next week or so, that's all I would ask. Again, the reason, and Your Honor, the reason it's entitled sanctions is because we went through it wasn't your court, Your Honor, but it went through compel. And then after a while, you got to call it something else, right? But I am not here asking for sanctions against Mr. Gibson. I know that.
Mr. Gibson, does your client not want to sign the authorization?
No, I don't think that's an issue. If council will send those to you right now, I'll have my assistant Anna, who lives in Westlaco, go by there today and have him sign them.
So I'm sorry. I will send them.
Go ahead, sorry.
I will send them today, Your Honor, and if the court could order him to have them return those to us within a week's time, I think the rest of it, I'll get with Mr. Gibson and we can work it out, Your Honor.
Joe, would you mind sending those to me right now? So I have, it's on fresh in my mind. I can take care of it.
As soon as I can step out my office and tell Bennett, my legal assistant, to do that.
It's just a solo practitioner. When you have 145, 150 cases going, you want to strike when it's fresh in your mind.
I completely understand.
All right.
Okay, so I'll go ahead and I'll give you all an opportunity to try to see how much of it you can work out. So send those authorizations over to Mr. Gibson. Mr. Gibson, have your client sign it within the next 14 days.
Okay.
And then that way you can also be doing that. I think that if Mr. Gibson was the one that was dragging his feet and not wanting to do it, then I can see where I would be compelled to want to issue sanctions or something, but that's not the case. And I mean, I've dealt with governmental agencies before, and it is very difficult. And so, I mean, I'm going to give you all an opportunity to try to work out as much of it as you can. But, now that you'll get your authorization as well, Mr. Escobedo, and then you'll have that within the next 2 weeks, and perhaps maybe between both of you requesting those documents, and maybe you'll finally get enough information so that you can move forward with the case. You will either, I'm not going to make a ruling with respect to the sanctions or anything like that, but if you need it heard in the future, just file an order resetting hearing.
Will do, Your Honor.
Okay.
Maybe.
All right. And so let me ask you, those are the documents that I'm assuming you will need those documents in order to do a fruitful mediation if it gets to that point, correct?
A fruitful mediation and obviously a fruitful deposition prior to the mediation. Yes, you're absolutely correct, Your Honor.
Okay. So then do we already have you set for a status hearing in sometime in the near future or not yet?
My calendar does not show any status hearing. We have no status hearing set on my calendar.
I think that's correct, Your Honor. So if the court wants to provide us a status conference, that'd be fine.
All right, February the 16th at 9:30.
February 16th at 9:30. Yes, Your Honor.
All right, the status.
Okay, hopefully by then everyone will be singing a different tune.
Yes, ma'am. Thank you so much.
Hopefully we won't need to come to the status hearing. We'll have it done.
There you go.
All right, y'all take care. Thank you.
Thank you, Your Honor. You'll be careful. Bye.
Thank you.
Hey, Lucy.
Okay.
Bye.
Ms. Williamson, thank you for accommodating us and coming on a little bit earlier.
Yeah, and I apologize for being late. They had not updated my schedule.
You're set for 11. We had just barely called your office. Don't worry about it. So you're set for 11. You're actually still early.
Yeah. Your Honor, and I was unable to reach my client right now. She still thinks that it's for 11.
Okay.
We're still trying to resolve this. If the court would give us an opportunity, give us another date, we'll be the other party's pro se. So it's kind of hard to get a hold of them.
Yes, I know it is difficult to work with a pro se client on the other side. Sure, how much time are you requesting?
Your Honor, at least a couple weeks, 3 weeks. I don't know. Then we get into the holiday, so maybe December.
Well, if it's agreed to, I can squeeze you in on December 15th. If you're not sure, it would have to wait till January 31st.
Your Honor, I would ask for then January, because since it's a pro se defendant, respondent.
Okay, January 31st at 9:30.
Thank you, Your Honor, and we should have it finalized by then. Thank you very much.
Thank you. Have a good one.
You too, Your Honor.
Okay, that concludes this morning.